Eminence would also be willing if asked to accept conditions, and there are 3.
Yes.
I do usually like to play my hand, but I think it's unlikely I would recommend such conditions, so I can't put it out.
Yeah.
But I feel that I ought to make a possibility available to Secretary of State.
Yes.
In which case it would be useful to have worded, yes, agreed at least between yourself and the City Council. Yes. I would save the opportunity to comment
Yes.
on it, together with reasons either that are justified or why the City Council thinks that they're going to be appropriate. If that follows on after the close of the inquiry, I would accept.
I'm grateful, but I think we can do it before the close of the inquiry. And can I say, we and the city have always shared your provisional view that you've just expressed, that they wouldn't be necessary and there may be trouble with the tests. But you were asking about intention and the ability to place weight. And at all stages, we've made it clear to the relevant authorities that if they thought that would help, we'd provide.
Yeah.
Without those being necessary.
It's I forget the judge, but there was a case where a judge said inspectors should provide reasons, but not reasons for the reasons.
Correct.
And that's sort of what I'm after. I'm after evidence, but it doesn't have to go to the nth degree.
I'm grateful.
Finally, I've had an email that the editor of the Architects Journal, something I do occasionally read, wants to submit an article to the inquiry. Any objections to that?
No objection to it.
Okay. Tell much in due course. Right. Anything else before I ask Mr. Harris to pass it down?
There was one thing that came as a bit of a surprise to me during the evidence in chief, and I've raised it with my learned friend, probably generated more heat than light, and that was the suggestion that there'd been an agreement as to various matters of fact. And that certainly came as a surprise to us. I don't need to go into it now, but I think calmly we can deal with that outside of the inquiry by presenting you with the actual facts on an agreed schedule.
Right.
This was relating, I think, to a single fact, so which was the difference in height between the Selfridges cornice and the canopy of the application scheme. And Mr. Porter, in evidence in chief, said that he thought he secured agreement as to 5 metres. That's clearly not the case from what member requested. So, of course, we'll cooperate on any discussions outside the inquiry.
I'm grateful.
So, just one from me before I hand over to Mr. Harris. I'm very grateful for the opportunity to be able to read this document in the short adjournment. And in light of what is said in this document, I'm satisfied that I can make submissions in closing in relation to it, and I don't need to ask Mr. Porter any additional questions in evidence in chief.
That's helpful. I should have started with that.
Not at all.
Right, Mr. Harris.
Thank you very much. Mr. Forshaw, I'm not going to deal with the merits of the proposal. We're a very experienced inspector. He's heard from both sides. I'm going to deal, if I may, with the decision-making process and how your evidence fits into that. Does that make sense? And I note from your evidence that you are giving the heritage and townscape issues as well as the overall planning balance. That's your position, isn't it? I also note, and I'm familiar with, your experience at Islington, where from 1975 right the way through to 2007, you were employed in various design office and conservation and design office roles. Is that right? And I don't think at Islington you ever undertook a generalised planning role. You were always on the conservation and design officer side.
That's not entirely true, actually. I'm a qualified town planner.
I understand.
And in terms of doing things like master plans,
Yes.
Public realm improvement schemes, dealing with planning applications, we did that. So I did that. So I had a pretty all-round experience.
All right. I'm just going on what you said in the proof, and from my understanding of your experiences, I've experienced it since 1985. All right, good. First heading is approach to non-designated heritage assets. And we can run through these, please. This is the approach that the Inspector and the Secretary of State have got to take as a matter of policy and a matter of law. No part of the application site is listed, that we know, correct? We know because there's a certificate issued by the Secretary of State of VCMS that it's not listable either.
Yes.
Thank you. And we know that the 20th Century Society, I think supported by you, have in fact made more than one application for the Orchard House building to be listed. Is that
I
right?
think that's correct.
Yes. And on more than one occasion, therefore, it's been considered by Historic England, most recently very up to date, and that application has been unsuccessful.
Yes.
Thank you very much. And we know, don't we, that as part of the Historic England consideration, there was a report drafted, and we know from that report that they specifically had regard to the original staircase at Orchard House.
They did in the certificate process, yes.
Thank you. For your notes, sir, that's page 3, CD 507. At page 3.
I was aware of that comment.
Yeah, because I think it's referred to in, to be fair, I think Mr. Forshaw refers to it and Dr. Mealy. So that's why you picked it up, right? Good, thank you very much. And as to the staircase, of course, SAVE are calling 3 witnesses at this inquiry, 2 now, and we heard from Mr. Sturgis yesterday, didn't we? We did. And Mr. Sturgis is urging on the inspector that there might be a viable and deliverable alternative, and part of his viable and deliverable alternative it involves the removal of a number of cores to the building, doesn't it?
Yeah.
And I'm presuming, as you're giving the overall planning evidence, that you've been liaising with him closely on what's appropriate and what's not appropriate in heritage terms, because of course there's no point having a refurbishment scheme that's unacceptable in heritage terms, correct?
Yes, I mean, I have discussed this with Mr. Sturgis, and we agreed that there may well be, as a lot of schemes, there are compromises, and it may be that that staircase is in the way. So perhaps you would rescue the railings, the jazz railings, and reuse those somewhere.
Yes. Do you know, when you gave your evidence in chief, did you not think to explain to the inspector that on SAVE's own scheme the staircase goes?
I didn't explain that.
No, did you think to? Did you think, as part of your responsibility to the inquiry, it might have been a relevant consideration to explain that in the scheme that SAVE is putting before the inquiry, the stairs go?
I could have done, but I think it's from the presentation that Mr. Sturgis gave yesterday, that's the case. What I was setting out was the merits of the
Right. Well, I don't usually ask, and so you've no obligation to answer, but I wonder, did you know that the stairs are going with the Sturgis scheme?
It was clear to me there was a lot was going on. I don't think I put the 2 together, so thank you.
Well,
And I mean,
to be frank, neither did I until fairly recently.
yeah, and maybe, you know, the Sturgis scheme is not the, as he said, it's not a completely fully worked up scheme.
And now we've got-
Who knows what design tweaks might be possible?
Yes, but you see,
Yeah, keep it, I don't know.
can we look at his document that was handed in yesterday to slide 31? What's the?
I got a hard copy of the resolutions.
Yeah, the hard copy will be here.
It's anything.
It's on the website as inquiry document
Yeah.
32.
Yeah.
Sure, download. I know it must be on the original one. So the slide 32, 31, bottom left. It appears in a number of places actually, but it looks like that. And do we see there, on behalf of SAVE, cores removed on the Orchard Street facade,
Yes, I see that.
and it includes the stair going, doesn't it?
Yes, I do.
Yeah.
Right.
And of course, insofar as the application scheme is concerned, the elements of the physical nature of the stairs you spoke of that could be retrieved and recorded and kept and reused could similarly be kept and recorded and reused for any redevelopment, couldn't they?
They could be, but I think that is not proposed at the moment.
Yes, and I've not noted anybody suggesting that there's a need for a condition in relation to that, but so a matter for the inspector to consider. So levels of protection not listed, not listable. The stairs taken into account by Historic England when refusing a listing, and also taken into account when granting a certificate of immunity.
It's the latter that they were taken into account on, not the initial November. In the November consideration, they didn't do a site visit. I've seen that. Surprisingly, given that they are already on. Anyway, they did do a site visit in February.
And that led to the certificate of immunity. Good, which is comms.
Yeah, I said that out in the.
Thank you very much. And we now know that the SAVE scheme removes those staircases in any event. I'm going to come back to this later. The site is, apart from a small part which is to do with the drafting of the conservation area, outside the conservation area, as a matter of fact and law, isn't it? And as a result of all of those matters, Parliament has said, as a matter of policy, that this is a category of building that, in the public interest, doesn't need to get planning permission before its demolition, correct? You're nodding, but
Yes,
yes.
yes,
So,
yes.
can the inspector record that the local planning authority, the applicant, and SAVE agree with the propositions that are contained in my opening and in the document that was prepared for the inspector by the council?
Yeah, I think we agree that you know, the protection of the building is what it is. Westminster City Council set down their interpretation of what's required for demolition.
And let's take no issue with that.
No. Okay, good. And submissions can be made on fallback, but when we are looking at the levels of protection that government and Parliament set down for buildings, not listed, not listable, not in a conservation area, and has already been granted planning permission through the GDPO.
Yes, and that's why Wall Street's case before becomes the similarities considered. And we
Good.
know what the outcome there is.
Yes, I just want to go to this case, if I may. So we've got those levels of protection or absence of levels of protection. And therefore, we're dealing with a non-designated heritage asset. That's an asset which has some significance worthy of consideration in planning decisions. That's the glossary of the. And so that brings, does it not, paragraph 203. Wasn't very long ago when different paragraphs number and just tripped off the tongue. But it brings into play paragraph.
The blue ones don't trip off the tongue and onto the paper.
On paper, but we're so far into this NPPF. I think 203, dealing with non-designated heritage assets, should be taken into account in the determination. Yeah.
Weighing, isn't it?
Yeah, taken into account in weighing applications that directly or indirectly affect non-designated heritage assets. A balanced judgment will be required, having regard to the scale of any harm or loss and significance of the heritage asset.
It's quite similar, isn't it, to
No, it's very, very different from 202 with the greatest respect. Yes.
Are in there, aren't they?
Yeah, but this is part of the fasciculus, Court of Appeal tells us, is in play. And where you've got a designated heritage asset, it's very different from a non-designated heritage asset because there's a statutory code involved, isn't there? And if with the greatest respect, Mr. Forshaw, you believe that 203 is the same balancing as exercise 202, I'm going to suggest in my closing you're very wrong.
No, I'm not saying it's the same at all. Otherwise,
Very similar is what you said.
it involves weighing and balancing.
Yeah, it does. But it's not very similar. It's very different. And what we've got is a straightforward balancing, no statutory presumptions, no need to give considerable weight and importance, etc. It's a very different type of balance, is it not?
Depending on what weight you give to it, isn't it? It's, and the amount of significance that you
No, that's a different point.
contribute to the undesignated asset that
that's
has
a
been
different point.
altered or lost.
There's an issue here, which is a difference in quality as opposed to difference in quantity. A non-designated asset cannot be treated as if it were a designated heritage asset, can it?
No, statutorily it's different, but as I hope to explain in my presentation, level of heritage.
And not 202. And the difference is that the courts of say are important between those two paragraphs. All right. So no need for planning commission. It's an NDAH. So the balance is in play, and therefore you've got to look at the heritage benefits and also the public benefits
Yes.
in exercising that balance. Now, it's no part of SAVE's scheme, no part of SAVE's case, is it? That's the contrary. That the scheme before the inspector and the secretary of state is anything other than deliverable. Saying except that it's deliverable, don't they?
Yes.
They also accept, and in terms, that the benefits that it brings are capable of being delivered. The benefits which are set out in the statement of common ground are accepted as being benefits that flow, aren't they?
Yes, we do that.
Yeah.
But with the caveat that we think the majority of those benefits could be provided by a retrofit scheme.
Yeah, but that depends on a retrofit scheme being deliverable and viable, isn't it? Yeah. And if it's not, then what we've got before the Secretary of State is a scheme which everybody says is deliverable and everybody accepts meets the requirements for the site and everybody accepts meets the benefits set out in the Statement of Common Ground at CD 92. Correct?
Yes.
I'll give you the reference more fully, sir.
But put it in your closing.
It's paragraph 14 to CD 92. Thank you. Good. And if ask that, I don't need to ask that again. If the refurbishment is not viable, then those won't be secured. Let me ask you this, please. Where, if at all, in your overall general balance, do you consider the exercise of that balance in the event that a refurbishment is not viable?
I'm not.
If you don't just say.
Yeah, I don't cover that issue. Except.
Thank you very much. That's very helpful.
I'm very sorry. Because of the interruption, I'm afraid I didn't catch the question. I don't need to hear the answer again, but could I just
So
say
where in the
question?
balance does Mr. Thorshaw consider the exercise of the balance if the refurbishment is not viable? I got that correct.
That's exactly right.
Yes, I don't.
Yeah, right. Completely, because you don't.
Thank you. I'm very grateful, but it was just because the
Yeah.
Thank you very much. Good. And of course, those that are responsible for considering that 203 balance are the local planning authority and the strategic authority, aren't they?
Yes.
Yes.
And in this case, the inspector and the secretary of state.
Yes, they're following on, of course, but that's a decision that's yet to be made. Can we pick up, please, CD 302?
Okay, I guess I have that.
And we've had this quote before, but let's go to the summary so we can do it quickly. In terms of the non-designated heritage asset,
Put a page somewhere.
no, there's no
Page,
it's the second page. It's not paginated internally. But
it's item 2 summary.
so thank you.
Okay,
Where's the
yeah.
Are we
It's
on
the-
page 3 for the reference?
No, I think we're still on the bottom of page 2, so where it refers to the loss of the non-designated heritage asset. It then says, look, there's an application in for it to be listed. It wasn't even determined at this stage. In officer's opinion, the loss of Orchard House is fully justified in design and heritage terms. The new building is considered to be well resolved in visual interests as appropriate to sensitive historic context. Then they go on over the page. Significant improvements to the public realm and welcome will transform the environment of Glanville Place on the west side of the site and Orchard site to the east. The development is highly sustainable in accordance with the City Council's policies. The proposal includes significant urban greening, meaningful outdoor spaces, maximises on-site renewable energy in line with energy hierarchy. The new building would activate this prominent site on Oxford Street by providing a landmark building which will aid the regeneration of Oxford. The development would make a significant contribution towards economic growth, not only through the creation of jobs relating to the site, but also supporting the sustainable recovery of Oxford Street as a leading retail destination. Yes. So there's then playing those public and heritage benefits against the demolition. And those public benefits are all relevant. We may not weigh them as fondly as the officers, but they're all relevant, aren't they?
They are, and I've covered them in my proof.
Yes. Is that right, though? We're going to look at this in a bit more detail later. But where do you deal with for example, the recovery of Oxford Street as a leading retail destination?
What in my proof?
Yes.
What I'd like to talk about, regeneration. Proof that.
Yeah, please.
Yeah. Regeneration of Oxford Street. I mean, we're talking about balancing harmony. This is section 7.
Yes, I've got that.
The regeneration of Oxford Street. Talking about a discussion. In my proof, I think, about this issue.
Where am I looking? Sorry.
No,
That's
it's
18
8
onwards.
Yeah.
That's it, is it?
Oxford Street.
Okay.
Retail provision.
Yeah. All right. And in
Office space.
710, you say that really the big problem up here is traffic.
I do say that's a problem, yes.
All right. Okay. So I'll leave the inspector to look at that. And
That's
see.
part of the smell, I think. In that
Well,
one.
I think the smell is more of decay than of diesel, but that's a matter of opinion. All right, good. And we know the GLA took a similar view, don't we? Go to their stage 1, which is CD 402. Paragraph 28, where they too apply the right test, which is paragraph 203. It's non-designated heritage asset test. Page 7 internal, sir.
Thank you.
What paragraph, what was this number again?
It's 28.
28, sorry.
References framework.
Sorry.
Yeah, and then it says a balanced judgment has been made, having regard to the scale, the loss and the significance of the heritage asset. In this instance, the scale of the loss is total, but having regard to the limited significance of the non-designated heritage asset, the harm caused by the loss is considered to be limited. The proposed scheme would also bring about significant benefits, which include the construction of high-quality building, contribute positively to the town and surrounding conservation areas, the introduction of additional modern commercial floor space within the CAS, West End International Town Centre, and West End Retail and Leisure Special Policy Area that will contribute to the economic development of London and its role as a global city. The creation of new public realm and improved biodiversity and urban green. Having regard to the level of harm caused by the proposals and the benefits that the development will bring about, it's considered, say, the GLA officers, that the harm would be outweighed by the benefits of the scheme in this instance, provided that these benefits are appropriately secured with any planning permission. Now,
Yes.
two points here. The first point, all of those public benefits that are referred to there are accepted by SAVE as coming out of this proposal, aren't they?
Yes.
Second point, you don't disagree that all of those benefits are properly to be weighed in the balance in relation to the 203 exercise, do you?
They have to be weighed. I mean, what I'm saying with my proof in terms of this weighing exercise, if you look at this paragraph, is that the limited significance of the non-designated asset is something that SAVE is challenging.
Yeah, understood.
And also, I have in my proof questioned the amount of weight that's been given to some of the public realm improvements.
Yeah.
For example, the little pocket park.
Yeah.
Which is much hyped up in the application. I've heard that what a fantastic place it's going to be. I don't think it's going to be a fantastic place. It's going to be overwhelmed by the setting.
Yeah, I've understood that.
So-
The point,
So that's all part of the weighing exercise.
yes, understood. But we've agreed that's the exercise, that's the judgment they came to. Those are the things that you take into account, and you don't deny that those benefits come about. Now, one of your important, I thought, one of the key parts of your overall balance was to the effect that, well, don't worry, because these benefits could come through a refurbishment.
Yes.
Yes,
I think
and now
that's-
we know, as a result of the question that was repeated, etc., that SAFE simply hasn't considered the position if the refurbishment is not part of its case. Do you see why this might be central now?
Oh, well, we are saying, Mr. Sturgis
Yeah.
was saying yesterday, he was presenting the scheme that he thought would have a chance of being carried out.
I've understood that, but let's assume that the Secretary of State for the minute thinks that that's vanishingly small. I've got nothing. SAVE does not have a case, and my learned friend can't make one up, as to what the balance should be in the event that the refurbishment is not viable or deliverable, does it? You carefully listened to my question. The inspector
Yes.
repeated it. We repeated it a third time.
What,
You've not considered that.
no, I haven't, but I imagine that the Inspector and Secretary of State may well. What they may consider is this issue of possibility, likelihood, those sort of issues, as you know, has happened before.
Yeah.
We had it very recently on Custom House.
Yeah, but sorry, not, you simply,
But I accept that we have not produced a fully costed up viable scheme.
no, that's not the point. Forgive me, that's not the point at all. The point I'm making here is an elemental part of SAVE's case is that these benefits are goods. The Secretary of State should take those goods into account. We do not say, with one or two small exceptions that you've just outlined, that these are anything other than consistent with the development plan. In your evidence in chief, you said in terms, and I was grateful, the proposal does indeed comply with and contribute to the CAS and to the development plan aims and policies. A central part of your case is that, but you can get those anyway. What the inspector doesn't have is, what if you can't get them anyway? SAVE has just simply refused to address that, hasn't it? Steadfastly.
No, I think.
Where is it then?
Well, I think Mr. Sturgis's.
No, it's for you. It's the planning balance, isn't it? It's the planning balance, please. You're responsible for the planning balance. We've agreed that. We've heard yesterday the evidence on refurbishment and how likely or otherwise that is. And it was agreed that if it was not viable or deliverable, then refurbishment wouldn't bring the benefits. You devalue our benefits on the basis substantially, maybe we should look at CD 902. You devalue our benefits substantially on the basis that they could be achieved by a comprehensive redevelopment. Page 23.
Retrofit.
I'm reading it out. Say considers that a similar benefits could be achieved by a comprehensive refurbishment of the buildings.
Yes.
You said redevelopment before.
Said
That's why
I'm sorry. I apologise. In this case, I'm sure it was. All right.
So let me just find where it is.
So we're on CD 902.
Two.
902.
And very helpfully, what SAVE did here was they took the agreed statement of common ground, and I think as the inspector requested, indicated where they agreed and where they disagreed.
I did.
Yeah.
23, which was
Benefits. Yeah. Section 14, 14.2,
42.
there are 10 benefits there set out. They agree with all but one of them.
Oh, that's it. Yeah, yeah.
Thank you very much. Anyway, that's very helpful. Thank you for that. Okay, can I ask you about approach to other buildings now, please? Because we'll remind ourselves that the policy for this area is to seek transformation in townscape and urban terms and in functional terms. Policy is to seek transformation. Yes? And again, we looked at that yesterday. We don't need to look at it again. But I just want your view, please, as to the contribution that certain existing buildings already make. Can you pick up Mr. Pilbro's evidence and turn to, have you got that? Page 39.
CD number.
1009.
Thank you.
Which part is it? 'Cause
It'll be part one, I think, if it's that early in the document.
29.
39. Right, I'm only going to do this with the one building because everybody's been to the site.
Yes. This is the 3/4.
Yeah, exactly that.
Yeah.
Yes,
Okay.
yes. So we've got, it's useful for two of the buildings at least. We've got Granville Place there. And this is a sort of benchmarking question, really. It's a benchmarking question. Your view on the impact of that building on the settings of the conservation area, the listed building, and on the townscape generally? How would you characterise that?
The existing buildings.
Yes. No, the one on the one on the right.
Well, the big picture.
Yes.
Yeah, which fronts onto the return of Granville Place
It does.
and then the use. It is very much capable of improvement. I think we would all agree that.
Let's start
It's,
from what your view of the existing building.
What is reasonable about it is its scale. And I think I pointed that out when I showed that image of the view down Portland Use south from outside the pub. And talked about the building from there. The scale of the building is appropriate for that site.
What else?
Could you repeat the question?
Yes.
Asking to assess it.
No, I was asking you what your opinion was about the townscape contribution of that. Wait a minute. And the contribution it made to the settings of the listed buildings and the conservation area. That's the question. And you came back with, well, it's capable of improvement.
It
You can
is.
see why
It
the
is.
inspector's asked me to ask the question again.
Um,
What is the contribution it makes, please,
to a listed building,
to the settings of the listed building?
well, the nearest listed building is 10 Portland Street. The other buildings in Granville Place and Portland South are non-designated heritage assets. The real impact is the conservation area. That is the designated heritage asset that is affected by this, and I will explain that in my brief. The merit of it at the moment is its scale. What I accept is that the elevation.
All right, I'm going to try one more time.
Let's
It's in the
finish
middle of
answering
answering
the
the
question.
question.
Well, I hope so.
Elevation. Me
So
too.
the elevations are pretty grim, very solid, unbelieved. But as Mr. Sturgis said yesterday, you could put windows in, lighten the load, which would help get an extra story on top.
All right, I am going to ask the question again, and I'll ask you the way you'll be familiar with. Does it make a positive, a negative, or neutral contribution to conservation area? I don't know why you're finding it so difficult.
Well, these things are a matter of judgment.
They are. Well, I'm saying this
And
probably is.
I would say
And what's your judgment?
it's on the negative side. But it's not all bad. If you understand what I'm saying.
On the
It
negative
could,
side.
it's on the negative side, it could be improved.
Yeah.
So
So,
to make it, neutral, perhaps.
right. So I'm going to push you a little further because, of course, you form a judgment about the new building and its contribution to settings. And you say it's harmful and at the upper end of that's substantial. Let's just have a look at this just to see if there's an internal consistency in your approach. So on the negative side, I would take that to mean in terms of 202, that there was impact here which was less than substantially harmful to the conservation area. But where would you put it on the spectrum, please?
Degree of,
Harm, negative is harmful, isn't it? Yeah.
the existing building, not very high. I don't think it's very
Right.
high. Because I say the scale is.
Thank you. That's fine. Say it's benchmarking exercise and an internal consistency point. So that's not very harmful. You say it can be improved by the sort of punching in of windows that we saw Mr. Sturgis look at yesterday. Is there anything else I need to look at? That's all that's before us.
Well, there's the possible reorganising of the loading bays that we talked about, moving it round to Portland views.
Yeah, it doesn't work there. All right, good. All right, Orchard Street next, please. Let's look at the facade and the colonnade. I just want your view, please. That's in the setting of Selfridges, isn't it?
No, yes.
Yeah, because it's described by a number of your witnesses, or one at least, as unpleasant and unsightly. Do you agree?
No, I've talked about it in my proof.
Yeah.
And also referred to the slight mixed messages in Westminster Committee report.
Yeah.
So that's all in my proof.
So would you say this was harmful or neutral or what?
The existing,
Yes.
I would say it's neutral.
This
I don't
is
think it's harmful.
neither. So this neither harms.
I think there's a bit of 1970s architecture
Really?
spanning between Orchard House and Hester's house.
That's fine.
It's a considered piece of design, and Westminster officers agree with that.
Well, we'll see what they say later. But for my purposes now, this relationship neither harms nor improves Selfridges, and therefore
I think
that's good. So what that tells me, at least, something about your view about the actual sensitivity of this part of the setting of Selfridges. This you see as neither harming nor improving it.
Well, because what this building is opposite is the 1970s extension of Selfridges. It's not opposite the Burnham building. It's Orchard House that is exactly opposite the Burnham building.
Got that, and we'll come back to that. Good. So Neil House next, please. In your evidence in chief, you pointed to some of its features, and I'm going to ask the question. Just again for benchmarking purposes, is it your assertion to the inquiry that's neutral too?
Yes, say so in my proof.
Yeah, that's why I put it to you. Neutral. You say there's no case in heritage terms for its retention. That's the phrase you use.
Well,
No case.
it is not a non-designated heritage asset.
Yeah. I'll put it again.
But-
No case for retention.
Yeah, neutral. I mean, neutral is in the middle, isn't it? No case for, no case against, I suppose. The case, you'd have to replace it with something better.
Very good. Thank you. Let me just try it this way. Say, what would Save's position be, for example, if there was an application for planning permission for Neil House in its present form? Let's just sense check what you just said. An application next door to Orchard House for Neil House comes in. Say we go to say that's neutral, right, to the conservation area and to the settings of Selfridges and
If it was purely an application for that building alone, nothing to do with Orchard House.
Yeah.
Probably wouldn't be responding at all.
okay. But since I'm asking you what Save's position might be,
I suppose if a very sort of town was put up there, then that's going to have a much wider impact, isn't it? It doesn't Orchard House have an impact on Selfridges and God knows where.
all right, good, thank you very much for that. Just so I'm clear before we move on, we've heard from the learned friend that it's no part now of Save's case that a light refurbishment option is an appropriate consideration in Save's world.
Yes.
There are other people, and we've heard them, and
Third parties.
yeah, the third parties who do take that view. And we also heard yesterday from Mr. Sturgis that he was not suggesting that the site could be appropriately optimised by way of a facade retention. That wasn't any part of his case.
No, nor is it part of my case.
Not.
No, it's not. I included it in my proof. Discussed it because it was put into the planning office. Raised in there and knocked down. Biggest floor levels. That's not at all what I'm advocating.
I'm pleased about that. You say it was dismissed rather dismissively in your proof, which led me to believe that you might have something to say about it, but we needn't go there now. That's really helpful. So you're not saying there's a light refurbishment option. So you're not saying.
Facadism is not light, is it? It's demolishing everything except the facade.
Just bear with me. I'm trying to identify what isn't the case. No light refurbishment option. That's not the case. No facade retention. That's not the case. Leaving it as it is not the case. Save's case is squarely and solely on the type of Sturgis refurbishment that we looked at yesterday.
Yes, and I think that is also very much so to do with wanting to achieve the aims of CAS.
Good.
To provide good retail, to provide office accommodation, etc. As Mr. Sturgis has outlined, could be possible.
Perfect, thank you. Therefore, I can note, and will note in my closing, that Save accept that leaving the building as it is, in spatial, in carbon, and in heritage terms, is no part of Save's case.
It's not, but if that's what happens and things just carry on as they do, I mean, that's also a possibility. But I imagine that my suspense won't like that because, as we've seen when we walk around, services are badly upgrading, nothing's happened there for years.
Okay, thank you. That's all very helpful. Next heading is approach to the conservation area and what the Inspector and the Secretary of State are meant to do with your evidence here. We've already agreed it's not in a conservation area.
Just before you go on, you said Marks and Spencer's won't like it. Have you seen the note that was put in this morning that provides further evidence to suggest that they would close the store?
I haven't read it, sir, but I can imagine that they.
I mean, you've heard that earlier.
Yes, I mean, we've heard there's nothing to make them stay,
In the
there's
evidence.
nothing to make them return.
Yes, I mean, do you take issue with that?
Well, they say what they say now. I don't know what they will do were they to get a refusal. They say, I mean, that's possibly 6 months away. They may decide to close next week. I don't know. We know that they are unsentimental about, said that, they take a strictly commercial view. Fully accept that.
I think that answers. Carry on, please.
Well, I had that question to come
Oh,
later, sir. but-
I'm sorry.
No, not at all. But if you think you've got enough, then I won't ask it again. But your question was, and my question to Cam was, do you take any issue with the evidence that's been provided on that front? No. That's the direct answer. So we know it's not in. So the next heading, so and I'm sorry, I left ahead of it. The next heading is approach to conservation area. It's not in. There is no evidence before the inquiry at all that it's going to be put in, is there?
No, the only thing that's been said is by that councillor, Jessica.
Has that been before the inquiry? That's a conversation that was had.
No, she spoke. She spoke on the
She
first
spoke,
day.
yes, I know
She
she
spoke on the
did.
first day, and
She
she
didn't say
said,
anything about the conservation area.
she said,
Well, I'll check.
yeah, you check.
I'll check.
We've got a.
Yeah, we did her evidence. Yeah, I remember her giving her evidence and she stood up to give it.
She did.
All right.
Have a look at it. It's towards the end.
Yeah, I'll check. But so it's not in. Is that the only evidence that you have that's going to be put in? And did the council
Yeah,
have authority to say
as I
that?
said, we haven't had it. I mean, what we do know is that there's been a change in political control on this.
But the development plan is the development
It
plan.
is, it is.
And that's it.
Yes,
And the corporate body is the corporate body and that's it.
it is.
And
But
we can't guess.
the council has the powers to extend the conservation area.
The council has the powers to compulsory purchase the site. I mean, but where's that taking us? Furthermore, there's no evidence, is there, before the inquiry, that Westminster City Council, as a responsible city council, would deem it appropriate to extend the conservation area to defeat a PD right. The inspector used the word spurious. There's no evidence that WCC would deem it appropriate to extend the conservation area to defeat a PD right given by the government. Is there?
What, the council has a duty to, from time to time, to review its conservation area boundaries. You know that, that's accepted. In reviewing those boundaries, it's perfectly entitled to see whether those boundaries might be extended to take in a building that has affinity.
That's not the
To the
question.
character and appearance.
I'm really
So it would
sorry.
be entitled, perfectly entitled to extend a conservation area. In order
It would
to,
be entitled to. The question was, is there any evidence it would to defeat a limited development?
no. No,
I don't think so. Thank you very much. It's always had the power to extend it and at no time has it exercised that. Has it?
it doesn't seem so, no,
No,
which is
good.
curious over 32 years.
That's a different answer to the different question again, but I'm going to move on. Approach to designated heritage assets, please. Approach to designated. How do you want to play this? So it's 1:05. I think I've got about 15 minutes.
I'm happy that you carry on for 15 minutes.
I support that. It's okay with
If it helps, so unless something comes up in the next 15 minutes, I've currently not got any re-examination.
And I've got about 2. So let's see if we can press on and finish and
Good.
then.
And again, I'm just looking at approach here. Approach to designated assets. Let's use Selfridges as a litmus test here. We've got a range of opinion before the inquiry, haven't we?
About what?
About the impact on the setting of the Grade 2-star listed building.
Yes.
We've got the GLA, who find that overall there is no harmful impact on Selfridges or on any designated heritage assets.
Yes,
Correct.
that's what they say.
And so, can we just make that the note is para 29 and para 32 of their stage one, CD 402. It's repeated in the stage 2. we should just go to it, just.
DD 402. Okay. And that's in the document.
It's page 7,
Paragraph.
29, last sentence. After a full explanation of the Roman, Doric and Tuscan columns, etc. This is the GLA, probably look at more heritage cases than any other body in the United Kingdom.
Absolute nonsense.
N-
I think that the GLA,
Yes.
as I explained, are not the heritage expert for London.
No, I've understood that.
I don't think they look at more heritage cases than historic England.
In London, in views along Orchard Street, the same results obtained. As such, no harm would be caused to the significance of the Grade 2 star listed Selfridge building. That's their position.
It is their position, as I explained, they don't have a large expert heritage team.
Right. And what about Westminster? Is their team rubbish as well?
No, they do have very good people.
Yeah, and they find overall no harm. They find very limited harm to the setting of Grade 2 star Selfridges, which is outweighed, among other things, by the design of the building alone.
That's great, that's what they
Then
said,
we've got Historic England.
yes.
And Historic England, now very carefully, as they explained to the Holocaust Museum inquiry, calibrate in line with the new the new PPF guidance. If there is less than substantial harm, where on the spectrum they say it lies, don't they? Because that's important, isn't it, to understand that, so that it is a realistic compass for a decision maker to look at. So we've got no harm GLA, no harm overall WCC, but low end of less than substantial harm for Grade 2 Selfridges, but outweighed by other things. And Historic England identifying harm to the setting of Selfridges, I'm using this as just an example, at the lower end of less than substantial harm.
That's what I'm saying.
Yeah. Okay. And you are mid to upper end of less than substantial harm.
Yes, I am.
Yes. So would you accept that you're out of step there in relation to the others?
I have a stronger view.
Yeah.
I think I'm
That's another way to do it. Okay.
quite in step with historic England, clearly completely out of step with the GLA.
Yeah.
And largely out of step with Westminster City Council.
Well,
I
you see,
think the nearest I'm with is to historic England.
yes, you are. But even the GLA take the view, and we can go to it if you like, but even the GLA take the view that if and insofar as there's harm, it is overwhelmed by public benefit. They consider both options, don't they? So there's the range that's before the inspector. You relied on Anglia Square in your evidence in chief to deal with this potential for setting harm to be towards the upper end of less than substantial. Is that right?
Yes, and I did that really in response to your paragraph 117 of your opening.
Yeah, where I referred to a very recent case as opposed to one that's now at some age. So should we just rehearse this with the inspector? We'll see it. Cancers on the meaning of this, haven't there?
Well,
Since and maybe as a result of.
What
Maybe.
cases are you going to put to Mr. Forshaw?
They're the ones that are referred to in the Samsung document that we already have. That's why you've got it. So should we look at how this went, please? And the inspector will be familiar with it, so we can deal with it really quickly. It's paragraph 35. And in particular, paragraph 44, which you put up on the screen.
Oh, we're on to the Anglia Square thing.
Yeah. Because, you know,
Yeah,
and there,
that's another report.
it's
Yes.
a letter, I got the report as well.
Fine.
So let's bear in mind that it is the report of David Prentice, who the inspector will know well, very, very senior inspector, very well used to dealing with historic buildings, and a similar case law load to the inspector, often in London. In paragraph 44, we get the Secretary of State's decision. It's noted in parenthesis in the run-up to an election. Paragraph 44.
What election was that?
It was the election. Well, who knows? We've got so many.
Presently, we are.
Is that a material planning
No, it's
consideration?
not. I don't give evidence, so who knows? But I'm sure the Secretary of State will take it into account. Secretary of State said this: he agrees with the inspector for the reasons given in IR 502 that be a harm caused to the Church of St. Albert, setting harms the almshouses. However, he disagrees with the inspector regarding the level of harm. He says, given the height and bulk of the tower, blocks E and F rising above the existing roof line of the almshouses, and given the tower would compete with and distract from an important bit of the church tower, the Secretary of State considers that the harm caused here would be substantial. And then he goes on to say, and in framework terms, as if he wasn't considering it in terms of the framework up until then, at the upper end of the less than substantial scale, and then for the reasons he gave. Now, I don't suppose in a month of Sundays, this inspector would use those words. I mean, can you help the inspector, please, with this? There was a challenge to this decision, wasn't there, on the basis of that substantial, less than substantial, what's going on here?
Mhm.
And that challenge was never heard because Historic England and the developers were able to go to Norwich with a scheme that they both found acceptable, which I now think has got or is on the verge of getting permission. Is that right?
I don't know. Henrietta is shaking her head. I think it's still in
Still in
negotiation.
negotiation. All right. Well,
We don't want to examine that scheme.
We need to
I
have some actual evidence relating to this.
yeah, I think just the witness to answer questions.
Yes.
Not answer.
Yeah.
if you don't know,
I
say.
don't think the end of the square scheme is resolved yet.
Right. Okay. See, the difficulty I've got is this could easily have been put to Chris Mealy, who gave evidence in that case, but wasn't. I received this last night, and I've not now got the benefit of asking Mr. Mealy about it. So we're in an evidential hole, but not of our making. But
Well, all I put this in for
yes,
is to show that it is possible to find
Yeah.
a higher level of less than substantial harm in terms of setting.
well, it is if this type of approach that the Secretary of State adopted, as opposed to the experienced inspector, is going to be followed. I'm sure. But we've got so much better example, haven't we? Very recent example, July 2022, Secretary of State. This should have been forwarded to you, sir.
I think it was. Do you remember when? Do you know when it was?
It would have been around 10 o'clock.
This is 117.
Yeah, here we are.
Yeah, so no, you've got the decision.
Yeah,
Okay, right, I've got it now, thank you.
Okay.
read it, you mean?
Yeah, it's been very widely read, not least for the reliance that it places on one of your decisions, sir. But can we start at page 77? And indeed, the Court of Appeal have upheld the decision also.
But it was nothing to do with this point.
Nothing to do with this point. No, this point was was accepted as appropriate. It was to do with private law. Yeah, private law. Exactly. My analysis is therefore based on the position at the time of writing. The point was not made in these terms of the inquiry, but for my part, I see little between the decision of the High Court in Bedford, Court of Appeal in Bram's Hill, and the PPG. Essentially, substantial harm is set at a high bar, such that a good deal, or all the significance of a designated heritage asset, would have to be removed for it to be reached. That means that the range for a finding of less than substantial harm is very wide indeed, from a harmful impact that is hardly material to something just below that high bar. Do you agree with that?
Yes, I do.
You do. In cases where the impact is on the setting of a designated heritage asset, it's only the significance of that asset that derives from its setting that is affected. See that? Do you agree with that?
Yes, yeah.
Good, we're doing well. All the significance embodied in the asset itself would remain intact. Do you agree with that?
Yes.
Yes. In such a case, unless the asset concerned derives a major proportion of its significance from its setting, then it's very difficult to see how an impact on its setting can advance a long way along the scale towards substantial harm to significance. Do you agree with that?
Yes, I do. And that's why I explained, giving evidence,
Yeah.
why I think the setting of Selfridges is such an important part of its significance.
So the major
Presence and swagger, as you said.
well, its presence and swagger is obvious, whatever's in its setting, isn't it? A major.
Well, I would disagree there.
Oh, fair enough.
Heavily disagree on that.
Do
And
you?
if you start putting up buildings that compete with it, as I said, how many buildings can you have in one room?
Yes, that's a setting impact.
It is a setting impact, and that's what we're talking about.
And then you look at the locked-in impact, don't you? And you ask yourself, where's the major proportion of its significance?
We do, and
Yeah.
you could do the same with St Augustine's,
Yeah.
which is a medieval church with an interior.
Yes, yeah, exactly why we say that. The inspector was right in that case and the secretary was wrong. But that's not the point. But I'm pleased you adopt then Mr. Griffith's way of looking at things. It's set out in 1250, do you? And therefore you'd invite the inspector to look at the significance that was embodied in the asset itself. The Secretary of State here has got an even nicer term for it. And then to judge what proportion is embodied there and what truly is embodied in the setting.
Indeed,
agree with that?
I'm inviting the inspector to judge what the harm is for Selfridges.
But no, but there's a technique, isn't there? You can't just say that. With the
Well,
greatest
the
respect.
inspector will have to consider
Well,
all aspects.
sorry, we've got somebody saying it's up here and everybody else saying no harm or down here. And I want to understand the approach you've adopted. Have you adopted this approach?
I have indeed. I
You
have looked at the heritage significance of Selfridges, and I think the setting is a very important part of it.
Okay, good. Let's look at paragraph 13 and at what the Secretary of State actually says. Page 3.
This is in the same document.
Yeah.
Paragraph 13.
The Secretary of State agreed that the overwhelming proportion of significance is locked into its form and fabric.
Recommendations.
We need to go back.
to the top.
We need to go to the Secretary of State's letter.
Sorry.
Yeah, that's right. Yeah,
Yes.
Secretary of State found that the overwhelming proportion is locked into its form and fabric, and that harm that would be caused to the setting and thereby the significance of the church would be less substantial and very much at the lower end of the scale as a result.
I see that, and it says, of course, the Church of St Thomas of Canterbury does derive something of significance.
Yeah. But it's the relationship between that which is locked in and that which is setting inspired and goes to significance. Do you agree with the approach?
Yes.
Okay, that's very helpful. Thank you very much. In terms of the conservation area, just one point. Conservation area settings. They are different from just the building settings, aren't they?
Yes.
Why is that?
Well, conservation areas are a wide area, aren't they?
Yeah.
And, I mean, as we discussed at Norwich, a conservation area can be massive, huge, and so setting there could just part of the conservation area that's
Yeah,
affected.
but legally there's a difference, isn't there?
It's covered in different sections, isn't it?
No. So a list of buildings setting is covered by a different section. There's no statutory protection for the setting of the conservation area, is there?
No, although one can, it's certainly a valid consideration to consider whether something is harming the setting of the
Oh,
conservation.
for sure, nobody's suggesting otherwise, but the point is, the statutory protection, the considerable importance and weight provisions are not engaged, are they? Are you aware of that?
Well, I think it's something that should certainly be considered.
No, sorry, were you aware that the settings of conservation area are on a different statutory footing? No statutory
Yes,
footing.
yeah, but there's still something to be
Oh,
considered.
for sure,
Yeah.
sure, but the considerable importance and weight provisions don't apply, do they?
You understand what it means
Yeah.
by considerable.
So, yes.
All right, well, I know you do, so which is probably more to the point. Right, overall planning judgment. Here's some, I just want to find out where we are in the round. You agree with Mr. Sturgis, and you accepted from me that the existing buildings in planning and sustainability terms are not doing their job, they're failing.
As at the moment, yes.
Thank you very much. There's no part of your case that a facade retention ought to apply or that a light touch ought to apply. Do you agree with the council when they say there is an urgent and compelling need for change here?
Yes, in terms of trying to improve the western end of Oxford Street.
Brilliant, thank you. You agree that our proposal meets the requirements for the site, and you agree that the benefits that come forward and have identified are, with one or two exceptions which you've explained, you don't need to re-explain, are deliverable. See the statement of common ground.
Yes.
There is a suggestion that there might be a refurbishment option. Nobody is suggesting that there is.
Well, Mr. Sturgis has put his case.
Yeah, well, we heard what he said, and I put that to him, and he
Not-
agreed.
not adding anything.
We also agree that there needs to be a viable and deliverable refurbishment. If there's not a viable and deliverable refurbishment, then a refurbishment option has no benefit, as he agreed yesterday.
Yes.
Thank you. We know from yesterday that the scheme produced, and large parts of it we saw for the first time yesterday, had not been produced with the benefit of any retail or office market or any other expert evidence.
No, Mr. Sturgis produced the scheme.
Yeah. And did you provide him with any retail or office market evidence? Not your field, really.
No, I mean, he did go and visit various other Marks and Spencer stores, which we suggested, such as the one in Clapham.
Okay, and therefore in the overall planning balance, well, the question, if you like, is whether the agreed and undoubted benefits of the proposal ought to be set aside on the potential for there to be a refurbishment option.
Well, I think the decision also has to be taken about a balance between the benefits of the scheme and the harm that it causes.
Yes, I've got-
And we are saying that the scheme causes harm.
But you've not done the exercise absent a refurbishment scheme. We've established that. And anybody who has done it has taken the view that the proposal ought to succeed. Doesn't bind the Secretary of State or bind the investor, but they're the dominoes in play.
Yes.
Thank you very much. Those are my questions.
Thank you, Mr. Fraser. Do you have
Just one question, if I may, in the examination, sir. Mr. Porter, you were asked about your calibration of where on the spectrum, where on the scale of less than substantial harm you would pitch this particular proposal. And you were also asked some questions about the general planning guidance. Can I just ask you if the inspector and Secretary of State were to align themselves with, for example, historic England in terms of where on the scale the harm is, rather than with your identification, what would your evidence be as to how the Secretary of State should strike the overall plan?
I would say that given that harm has to be given very great weight, that in the planning balance, following historic England's advice, we should still weigh the harm of the scheme higher than.
Thank you very much. So can I just make one point in relation to one of the questions that my learned friend asked, and that was about the Anglia Square Secretary of State decision and some litigation that arose in relation to it.
Right.
And my learned friend's going to make closing submissions about that, which he's obviously entitled to do. For my benefit, it would be very helpful to see the pleadings and potentially the consent order in relation to that litigation, so that I understand what is being said, so that I can deal with it in my pleadings. Obviously, Alan is going to go last in terms of that.
That's fair enough. I'm not going to refer. I've got so many other things to deal with that are more important than that.
Fine.
But I wanted the inspector to understand the context. The form part of my.
It's not one part of closing. I don't need to see it. Thank you.
Splendid. Let me just go through. You talked about the deferential nature of Orchard House to Selfridges, and you talked about the chamfer. But why do you say that's deferential rather than just different?
Because when my slide perhaps didn't illustrate it clearly enough, that the splayed corner removes the need for the existence of a sharp right angle corner.
Yes.
It means there is more sky space between Orchard House and Selfridges, so it preserves the clear view of the Selfridge cornice against sky more than if Traherne and Norman just done a square area.
Right, thank you. There's something I asked, which witness put for the applicant. Are you aware of any inquiries where whole life cycle carbon and circular economy have been main issues?
No, I'm not, and should really have been a question for Mr. Sturgis or Julie Godfrey. So
Well, she didn't say it.
I can't.
That's okay, that's right. And that's all my questions. Thank you very much. Right. Does that conclude all the evidence?
I think it does. So yes.
Okay.
So the statement of Common Ground on air quality.
On
Air
carbon.
quality.
We could do one on air quality.
A very short one.
I think we've already responded to that. Yes, well, I mean, I think it's currently with the applicant, so I'm sure I'll get an update.
Right. Will I? Well, first I could.
Yeah. It's back. Maybe
It's not back, no. We received some comments about 10 o'clock. I had a look at it in the short adjournment.
And then it came back to us.
And then it came back to you.
Right.
Yes, so it's been with you since about 11:30, so it's been the last 2 hours.
It's been back and forth more than beyond balls, tennis balls, and so I mean, it really should be close.
We should be pretty close now. So given I've seen the most recent iteration of a very close indeed.
Can I see the latest iteration?
I don't know, so is the answer.
It's quite a messy document and it's got quite a lot of track change. So if you can just, I mean, so in terms of this afternoon, are you going to be remaining
I'll stay on.
as in the building?
Probably not, but I pick up email.
We can just send an email.
Are you happy for us just to send an email? It might not be the final version. I'm just thinking though, those who are having to draft closings will need to know what it says as well.
Yes, indeed. Yeah, I mean, I'd just like a chance to look through it in good time before we meet tomorrow morning, just in case that.
Yes.
Hopefully I won't.
I'm confident that we can get something to you with some cooperation. I think we can get something to you certainly by close of business today, if not sooner.
Oh, we should do sooner if we can. Okay.
Well, definitely by tomorrow.
Absolutely.
Okay. Anything else that's?
Well, so, given that there's quite a lot, especially for me as the applicant to cover, the prospect of starting in the morning, can I put an early bid in for 12?
12 o'clock.
That makes
Happy with
sense?
that? Yeah.
Yep. I think so.
Yeah. So I suppose the other things are the just the updated conditions and the words for those other three.
Yes, they've been worked on.
And the 106.
Nobody in the room can help me with that.
I think that's all agreed now, sir.
Okay.
It's
So
all definitely all agreed.
Yeah.
if I could have those three by 5 o'clock, that would be really
I'm sure we can do this.
And if it's sort of just before 5 o'clock, if you could warn whoever it is at Pins that would be sending it on.
Well, we'll try and do it by 4:30, so.
Yeah, Mark Bolton, so that they can send it on to me then.
So there's just one further thing that's arisen out of the evidence today, and that's just the reference to consultation procedures if it was to be an extension to the conservation area. Just as a matter of fact, I've got the statement of community involvement from the council that would assist you, and specifically page 28 of that. I'm content to hand round copies, but just as a matter of fact, that's the procedure that would be undertaken by the city council. If that's, I can show.
If you want me to have that, then yeah.
Page 28. Sorry. Do some table jumping.
Thank you.
I think it says in Westminster you've got it yourself.
Was that page 28?
Yeah.
Oh, yes, yes, yes.
I'm not sure I can just.
What we may use it for. Yeah, documents, are they all being added to the website and then a link will be made available so that I can?
Yeah, have you got a link already, sir?
I think I have. Is the same link reusable?
Yeah.
Okay. And there'll be an updated court documents and inquiry documents. As well.
It's the Summerskill. The Summerskill decision.
Okay, yes. Do you want it to be?
Yes, please.
Yeah, it's on the, yeah.
Thank you. Anything? No, that's fine. Anything else? And until 12 noon tomorrow in this room, the inquiries are changed.